Hey guys, in this video, I'm going to talk about a recent court decision that makes it tougher to denaturalize citizens. Yes, that is correct. This decision will apply to certain citizens, however, so watch this video all the way until the end to learn these details. This is a timely decision, guys, as we're all gearing up for the incoming Trump administration and their expected efforts to denaturalize more citizens. This case is out of the Second Circuit Court of Appeals right here in New York, and the Second Circuit Court touches several states in the surrounding area, and this decision applies to individuals who are living in one of these states. The case is called Farhane versus the United States, and it involves a Moroccan-born man who had pled guilty to the federal crime of conspiracy and lying to federal agents. But he claims that he was never warned about the possibility of being denaturalized when he was trying to make a decision about whether to accept the plea deal or not. His attorney did not advise him about that particular immigration consequence. And as a U.S. citizen, of course, the last thing that you're thinking about is potentially being denaturalized. This decision requires attorneys to now advise their clients about this immigration consequence of denaturalization before the client accepts the plea deal. Farhane served 11 years in prison. He was released in 2017, and then in 2018, the government told him that they intend to revoke his citizenship and deport him based on his guilty plea. He says, "I would not have entered a guilty plea if counsel had told me that I could lose my U.S. citizenship as a result." Farhane argued that his lawyer knew he was a naturalized citizen, having advised the court of his citizenship status during his first detention hearing in 2005. However, Farhane claims that his attorney never informed him about the potential risk of denaturalization and deportation tied to his guilty plea. Watch my deeper dive into denaturalization and the grounds for denaturalization, and then watch the most recent one about how to lose U.S. citizenship, which talks more broadly about any U.S. citizen, including those who are born here in the United States. Denaturalization is a very difficult process. It is very limited. The government does not invest a lot of resources in denaturalization. Well, they haven't until potentially now under the new Trump administration. Watch those videos to learn more about these issues. The district court denied Farhane's motion, stating that there was nothing in the record to suggest that his lawyer should have known about the risk of denaturalization. But the Second Circuit Court of Appeals, which is the higher level court, extended the reasoning of a U.S. Supreme Court decision, Padilla versus Kentucky, which is a decision from 2010, which requires attorneys to inform non-citizens about the risk of deportation. The court ruled that the severe consequences of denaturalization and deportation are inseparable from the criminal process and must be disclosed to defendants. Specifically, the court said, "Today we hold that the Sixth Amendment entitles a naturalized U.S. citizen facing the risk of deportation following denaturalization to no less protection than a non-citizen facing the risk of deportation. Deportation following denaturalization proceedings is a severe adverse immigration consequence that is covered by Padilla. To provide constitutionally effective advice, counsel must address the risk of this consequence with her naturalized citizen client before he decides to enter a guilty plea." The court made this decision on October 31st of this year. Immigration policies are sure to shift in 2025, friends, and this particular case is extremely timely and will serve as a safeguard to individuals, at least those who are in the Second Circuit Court of Appeals jurisdiction, would allow them certainly to be able to argue this decision and fight against or push back on the denaturalization effort by the government following a guilty plea. That's the key here. This protection is for those who are going through criminal proceeding. That proceeding involves a plea negotiation, and so that's where this will be triggered. This case does not apply to individuals who are facing denaturalization outside of a criminal proceeding. So if you're going through a civil denaturalization proceeding that the government started against you, maybe based on fraud or misrepresentation that they are accusing you of during your naturalization application process, well, that's different. You will not be able to raise this particular case as a defense. Guys, if you're ever in a situation like this, absolutely lawyer up and work with an immigration lawyer who understands what denaturalization is and how to protect yourself from deportation. Guys, thanks so much for watching this video. Don't forget to subscribe to my channel before you go today and hit that notification bell so that you'll be the first to get notice of these videos each week. Thanks again, and I will see you in the next one. Bye-bye.